we enable our clients to pay the true value of prospects, enhancing budget effectiveness. From here on, I would like to introduce everyone to my good friend, Eli Schwarz. Eli, would be great if you can give a quick introduction about yourself and Verisk as well.
Of course. Appreciate it, boss. Good afternoon, everybody. Thank you for taking time out of your schedule to join us here today. My name is Eli Schwarz. I serve as the Chief Strategy Officer at Verisk Marketing Solutions, formerly known as Journaya or Lead ID, for those of you that go way back. I joined the company about 11 years ago, which is or was right around the time that the lead generation space was about to go through a major shift back then as the result of another FCC order, not too dissimilar from the one we're going to be talking about today. Back then, it was an update to the TCPA regulation that really required the entire industry to go figure out how to start capturing prior express written consent on lead forms. And a lot of what we see in our industry today and the way compliance operates is a result of that regulation change that occurred back in 2013, which today seems like table stakes, but back then was quite a difficult and new thing to accomplish for many of those companies that were generating and selling leads in this space. So back then, as Journaya or Lead ID, we were right in the middle of really supporting the industry through that change. We built a TCPA consent verification product that helped enable everyone to kind of continue operating in a compliant way with that regulation. And so, as Boss and I got to talking about the FCC's latest order and the changes that are coming, I think we both quickly started to realize there was opportunity to leverage some of that experience that we have from 11 years ago and try to help put what's happening today into context with what we've been through and what we've seen in the past, trying to help cut through some of the noise that's out there during this time of change. So with that, Boss, if you want to take us through to the next slide here, I think we wanted to start off just to set the stage for today's webinar and also the upcoming series of webinars that we're going to do here. Wanted to set the stage on a couple of themes and approach or expectations that we have. And I think we'll ask all of you who are watching this to help hold us accountable and provide feedback, make sure we're adhering to what we set out here as the intent. The first point really is that we don't think the sky is falling on lead gen. If you've been tracking along and reading the press and the articles that are coming out, it may sound that way at times, and there's a lot of fear, uncertainty, and doubt that's kind of being pushed around the industry. We don't think that's the case, and again, our industry has been through this type of change before. There's no question that there are going to be major changes to how we all operate, but our intent for this session is to kind of deliver information in a way that's not inducing panic. There's a need to move with urgency, but I think we can operate in a way that's calm and look at practical solutions to evolve and move us forward. So in terms of setting expectations here, Boss, if you want to jump to the next view, I think what we're aiming to accomplish is to be able to kind of really deliver clear, practical explanations of what's going on. We want to be very clear in delineating between what's fact about what's changing versus what's an opinion that we have and a view we have about what we think is going to happen. And then it's probably obvious to state this, but we don't have it all figured out. We don't know everything here. Anyone who tells you they do is probably lying and out ahead of themselves. So we're going to be relying on input and feedback from many of you to to help shape the conversation, and we're going to be bringing in experts along the way as we go through this series to help add color and add context in areas that we're not necessarily expert in. You see one of those on the call with us here today that we'll introduce here in just a moment. So with that, Boss, do you want to add any further color here on expectations and maybe some deeper context on the kind of collaboration that we're trying to create across the space?
Yeah, I think you touched on most points. Maybe just to add on this, don't expect a single silver bullet on these webinar sessions, but what we're trying to do is really lay out the different approaches that can be taken. And I think the message is that we should get ready, earlier than later in order to make sure that the industry is ready to make these changes. And it's really an ongoing dialogue. We need your input and your questions both throughout the webinar, but also afterwards. So we definitely stimulate reaching out all together in a collaborative way, which I guess brings us to the next slide, which is a great quote, actually, that we all feel very strongly about on this particular call. I wanted to say something about collaboration, because I think in times like these changes, collaboration is needed. And we actually started seeing that about a year ago. I was part of the formation of the technical committee within PACE and Consumer Consent Council about 10 months ago, with the sole purpose to tackle these type of challenges that might occur from either regulatory changes or other changes within industry. And the goal why we created that committee, as part of the committee, both Verisk and PX were part on that, but also Active Prospect, Barbara Du, Leadspedia, and Nura. And we continue to have these conversations today, was to educate all the companies in the space and to work together to offer technical solutions and primarily automation, to see how we can make this as easy for all stakeholders in the industry to navigate some of these changes. And for that, the collaboration we think is key. And I think just to round up with that, it's just so important for us to get that feedback as well. Before now, we're really pushing it off, Michele. I apologize. Now looking at the slides, we should have introduced you way earlier. But before we jump in with Michele, and we'll do a proper introduction, I wanted to share a poll that was recently conducted by PX. And I think there's two interesting facts in this particular poll. Obviously, the number one opinion of 33%, where many in the industry feel that this is actually a good change, that we need some change in the industry. Now, I don't think everyone would agree to that, but change would most likely result in better consumer experiences. And we'll talk a little bit more about that in today's webinar and the next webinars. But more striking maybe is that 42% are stating that they don't know what the actual impact of this is. They don't know what it is for the industry. They don't know what it is for their business. And I think that's really the reason why we're all here together to provide some education and to provide some collaboration on this topic to tackle it all together. Now, without further ado, I would love to introduce you guys to Michele Shuster. Michele, maybe you can give a quick introduction from yourself.
Sure. Like Boss, I worked with PACE and CCC, Consumer Consent Council, for quite a long time. Started with PACE prior to that 2013 order, and so was very involved with that and that process, ultimately leading to appeal of the 2015 order, so which was successful and which we won. So we have a lot of experience in this area as to what is going to happen. And the one thing I would say from that experience is that there really is an opportunity here, like Verisk and like PX. Those are two amazing companies that rose to the top as the result of what they were able to do with compliance and in response to those market changes that occurred. So, I would encourage everybody on this call to think about this as an opportunity, and how is this going to make you stand out from your competitors that may not be as on top of these issues or making changes to their business at this point. And the crucial part of that is educating yourself. So step one, you're on this webinar. We start with education. There's a lot of information out there, so make sure you're getting good information and that you're staying on top of this. Also, I think you can anticipate that we will be hearing more from the regulators about these changes, and so pay attention to that. If you're not signed up to get the FCC's newsletters and the FTC, Federal Trade Commission's newsletters, I really encourage you to do that, as well as your state AGs. And so now have been with McMurray and Shuster. We're 17 years old this year, which is just so hard to believe that I'm even old enough to have been here for that long, after having been at the Ohio AG's office for a little over 7 years. and was in that position when the do not call laws were going into effect. So if we really want to take it back, Eli and Boss, we'd start with those do not call laws in 2003. So, I like to tell people the only constant is change, and that has certainly been true in this area of regulation around telemarketing. And then I would also just say that, your customers are really going to be looking to you, those of you in the lead generation and marketing space, to make sure that you are doing what needs to be done and you're fulfilling your promises on compliance. And I think that will really, as we've already talked about, separate you. You'll rise to the cream, and really, I think will be an opportunity to increase your market share. So with that, one last thing, we always have to do the legal disclaimer as an attorney. While I am as an attorney, I'm not giving legal advice here. I will share some of my opinions. That is not legal advice. If you would like legal advice, give me a call. Always happy to have those discussions within an attorney-client relationship.
All right, so I'll set us up here to get started. I think we mentioned earlier this is going to be a webinar series, so we have three different sessions we're planning to cover. The goal here is to get started today with a deep dive into the changes, right, that are ahead of us from the FCC, and really focus first and foremost on what's changing from the current state of the TCPA regulation to what the future is going to hold. And that's where we've asked Michele to join us here and help give a great overview on that. So we'll focus primarily today on the facts and what we see coming. The next session, which we have scheduled for February 6th, we're going to dive deeper on more specifics around the way PX and Verisk, together with our solutions, the way we think we can help clients prepare for the future. And then the third session, we're going to be inviting a couple of other experts to come in and talk at a tactical level about the way they're preparing their organizations and the solutions that they're putting in place. So with that, I think we can dive into today's content. And Boss, you want to cover the agenda here? You want me to tee this up?
Yeah, I can give a quick rundown of the agenda and what we believe was most important to actually do a little bit of a look back towards the refresher of the current landscape of TCPA and how that came about. So we'll spend about 5 minutes on where we are today, and then obviously then on the facts in terms of the key changes that the FCC got approved and is planning to implement by Q1 2025. And we'll discuss a little bit what we think the impact will be for both lead generators and the buyers in the space. And most important for us is the Q&A section. So I do hope we have quite some time to spend on that. In order to participate on the Q&A session or section for that matter, please submit your questions through the Q&A chat function. It should be right on the bottom of your Zoom screen. And we'll try to answer most of the questions throughout this webinar, but we'll make sure that we follow up as well after webinar on any of the questions that were not addressed. Last but not least, the webinar is being recorded, and we'll also share the recording afterwards for all registrants. Maybe I can tee it up here to I think actually you wanted to start off, right, Eli, on this one. I wanted to say Michele, but I think you wanted to kick it off.
Yeah, happy to set this one up. I think so we wanted to take just a couple minutes to set the stage on what the current landscape with TCPA looks like, primarily to give you guys context as we start talking about what's changing. There's a few, I think, relevant facts about how things operate today to make sure we're all on the same page. I mentioned this earlier, right, that we see a lot of similarities between what's happening now with what we saw in 2013. And just to give a little bit more context on that, right, back then, the majority of the industry lead gen space was able to operate with primarily implied consent, right? When a consumer submitted a form with a phone number, it was implied that they were giving consent to then receive calls and follow up. But the 2013 regulation change made it so that it was required to have prior express written consent. And so that drove a lot of conversation and change in the space where we saw companies kind of racing to figure out how to add disclaimers to all of their lead forms. And there was a lot of fear, primarily around, whether doing so would kill the conversion process, right? Would consumers drop off and no longer submit their information if they were forced to look at a heavy disclaimer before submitting it? And then, like, how would everyone prove that consumers gave consent? Because with that regulation, the burden of proof shifted to the company that was calling the consumer to be able to prove that they actually, obtained their consent before those calls. And so when we look at like the landscape today and how the industry operates, we see these standard TCPA disclaimers that are pretty much always included on a lead form before consumers submit that form. And in the way current state operates, we often see brand names of the companies that are going to call the consumer are not always listed in those disclaimers. So often there is a hyperlink in that disclaimer that links out to a long list of different companies that might follow up. And that could be hundreds of companies or even thousands in some cases. And then we also see like multiple products and services that can be marketed to the consumer who submitted a lead where they only gave consent, one time, but it was pretty broad and enables then multiple different types of companies and products to follow up with them. So sharing this because these are a couple of the distinctions we're going to come back to that are changing. And then I think a couple more details and nuances to step through around how current state PWC and EBR and DNC operates. And I'll leave that to Michele to step us through some further detail here as we set the stage.
Yeah, the only thing I would add to that, Eli, is back in 2013 is also when they removed the existing business relationship exemption that allowed you to make those types of telephone calls without having consent. And so, one of the things that folks were looking at back then is what was the definition of an automatic telephone dialing system that now folks that had an existing business relationship were going to have to get consent for. And we all know about the long and troubled past that had with the 2015 order the FCC put out that made everything that wasn't a rotary dial-a-phone, an automatic telephone dialing system that ultimately led with the Facebook versus Duguid case. So, I think the point that you guys made really well at the beginning of this webinar, that this isn't new to us. We as an industry have been very nimble and able to meet these requirements and actually thrive in those. And I don't expect anything different under this new regulation. So what we wanted to do was just kind of go through what the current state of the law is. And I like diagrams, I like flow charts. And so we put together a flow chart to just walk people through. This will be included with the slides. The basic structure of this isn't changing. What is changing is that bottom in red prior express written consent definition. And that's what we're going to spend some time talking about. But, basically going through this under the TCPA, the analysis for if you are using an automatic telephone dialing system or a pre-recorded message, what type of consent do you need? And I want to just start by saying, I mentioned the Facebook versus Duguid case, and I think we're all pretty comfortable at this point saying that if you are dialing from a list, so a list that's been curated through lead generation, and you're not randomly or sequentially generating telephone numbers, then you are likely not using an automatic telephone dialing system. Having said that, of course, rely on your attorney, get an opinion, but with the exception of one very serious outlier in Colorado, every court has held it if you're dialing from a list, it's not an ATDS. And so, for the most part, we really are looking at the pre-recorded message requirements here and what that means. I would also say before we start that the Federal Trade Commission came out before the Federal Communications Commission and interpreted their definition of consent to also include the one-to-one consent that we're going to be talking about today to place marketing telephone calls using a pre-recorded message. So, we have on the Federal Trade Commission side, also this requirement. A lot of people don't pay as much attention to that because that doesn't have a private right of action for the most part. You have to have actual damages that exceed a certain number that no one ever gets to because of a telephone call. But the attorneys general also have the authority to enforce the Telephone Consumer Protection Act and the telemarketing sales rule, which is what the Federal Trade Commission is responsible for enforcing. So AGs have been crazy busy lately with lawsuits. So although no private right of action on the FTC side, you still want to pay attention to that. And I would say that it mostly parallels what we're going to be talking about today. Okay, so let's go through this. So what type of consent do you need for a call or a text? Let's go down the left-hand side first for calls to wireless numbers. If you are using an automatic telephone dialing system or a pre-recorded message and it's informational, then you need prior express consent. And prior express consent has been defined by the FCC as when a consumer gives a business their cellular telephone number as a means of contacting them, and then the business is contacting them within the context of that, what that was consent was given for. So that's what we mean by prior express consent. No changes from the prior law to what the FCC order is putting out, so that remains the same. On the other side of that, if we're using an ATDS or a pre-recorded message and we're telemarketing, then we need prior express consent, and that's what we're going to be talking about with the new requirements. And then obviously, if you're not using an ATDS or a pre-recorded message, then no consent is required, except that we are going to go into the do not call rules. So just kind of put a pin in that for the next slides that are coming up. If you're calling a landline, so not calling a wireless number, and you're not using a pre-recorded message, don't worry about it, no consent required. If you're using a pre-recorded message and it's telemarketing, then you do need the prior express written consent. If it's informational, then no consent is needed. Next slide. So let's look at the prior express written consent, or really prior expressed invitation for the DNC analysis chart. So the question that we're answering here through this flow chart is, does the do not call laws affect how you can call? And basically what we're saying is that there are requirements in the TCPA that say if you are making a telemarketing call, then unless you have the consent of the consumer, you have to scrub against the do not call list. So the question we're answering here is, do you have to scrub against the do not call list before calling? Now, on the left-hand side, we talk about if the call is a business to consumer and it's telemarketing, and you ask the question, did the consumer provide written consent for the call? If they did, then you don't need to scrub for the DNC registry, and this is the national registry. I'm not talking about state registries, the national registries. If you don't have that prior written consent, then you do have to scrub against the DNC list unless an existing business relationship exists. Let's go to the next slide. We're going to be picking up, this was a long one, so we wanted to break it up into two, and we're picking up with does the EBR exemption exist with the consumer. And when we're talking about an EBR, an existing business relationship, that means that you have done business, the business has done business with the consumer within the last 18 months. That could be that there was a contract that would have expired, date of last payment, those types of things would show that you had done business with them. And then there's also a 3-month exception. You can call for 3 months when a consumer has made an inquiry to the business. And so if a EBR exemption does exist, then you do not have to scrub against the do not call list, as evidenced by going down the left side of that chart. If you don't have an existing business relationship, then a DNC scrub is required. And if the number is on the do not call list, then the call would be prohibited. If it's not, then you can make that telephone call to the consumer. So a lot of information there. You'll have the slide after this presentation, so it'll give you something that you can go back and reference.
Michele, it seems pretty complex already before even jumping into the changes. Do you experience that there's a lot of companies operating in the space today that still do not understand many of these items? And what do you normally recommend in such a case?
Well, and if you think about it, right, boss, we know because we deal with this, we deal with this every day, right, Eli, boss, every day. It's not even just these about what type of consent you need for calls. You also then have all the disclosures that are required, right? And then you also have all the 50 state laws that are a little bit different too. And so, what's really key is that before you start initiating any calling campaigns, or before you are selling leads and making representations about how those leads can be used, you really need to have a full understanding of all of these requirements. And, while it seems complex now, if you sit down and you really do just go through this with the lawyer, there are some key concepts that come out. The one key concept is if you have consent, that is the trump card. You can do all of these things if you have the right type of consent. If you don't have consent, then you're going to not want to use a pre-recorded message or an ATDS, and you're just going to want to look at whether you have an existing business relationship or some other type of exemption, like potentially a business-to-business call. So there are ways of doing this, and it's just a matter of documenting your compliance program and making sure that you have folks who you can rely on to give you good advice on how each one of those campaigns needs to be run.
Okay, so let's jump into some of these changes that that we should expect, and we'll do that through actually having Michele provide a quick summary, go highlights and highlight a couple of the more important details also around D&C, and then the e-sign. And from there, we'll actually have a table, which we all believe is the most important table to actually showcase during this webinar, which is the before and after of these changes.
Yeah, yeah. So the FCC, we all were notified that something was coming up in late last year, and then their December 8th open meeting, they passed a report and order that they had released, and then it was slightly revised on December 13th when it was released. The main elements of that report and order that we're going to focus on today, and the one you've heard the most about, I'm sure, is this concept of one-to-one consent. And it goes back to what Eli and Bas were talking about with the prior norm for lead generation. And that was that we, in lead generation, there were marketing partner lists that were being used that linked sometimes a reasonable amount of businesses, and especially in like comparison shopping websites, those types of things. And then there were lead forms that had thousands of companies that were listed. And what the regulators pointed to when talking about this one-to-one consent is that they believed no reasonable consumer would ever consent to being called by that many companies. And they're probably right. I mean, we have to admit this. There were abuses out there. And so what they were focusing on with this new rule is they wanted to make it so that a reasonable consumer would know without any question who would be contacting them after they signed off on these lead forms. And so they went to the most extreme case, which was one-to-one consent, meaning you had to get consent from one consumer to one seller. I will tell you, I think there's some room here. A lot have said that you can only have one seller on a lead form. I think there are ways that you can get creative with your lead forms, have more than one seller, but it would probably require individual consent for each of those sellers on that lead form. And especially if you're doing cross sales or if you've got affiliate offers that are happening there, then that may be one tool that you can use to get more than just one seller. But again, it's going to be based on the fact as to whether the consumer understands, and it's clear that a consumer would understand from the lead form exactly who's going to call them. The other part of this is that the FCC, and this threw the industry a little bit, I will tell you, the one-to-one consent, because when the FCC originally released a notice of proposed rulemaking, they were really focused on this concept of logically and topically related. And so it appeared from their initial requests for comments that they were looking to see how can we pass a rule so that if we do have additional companies that are listed, that the consumer would understand that it's only companies that are going to be calling them that are related to the website that they were on, and for the type of company they thought they were giving consent to. So, if you were giving consent to receive information about flu vaccines, it didn't mean you were giving consent to also get debt collection type of, or not debt collection, but debt repair types of calls. So a lot of the comments focused on that. It becomes important here in a minute. But the logically and topically related, it's to the web page that the consumer is signing off on. I think that's an important distinction because you can have various paths when you're going through lead generation forms that mean that you need to focus on which web page the consumer is providing their consent on. And that logically and topically has to be related to whatever the content of that web page is. And again, focusing on what the consumer would have considered what they were giving their consent to. These regulations in the initial order that the FCC released said that there would be 6 months from the date that the order is published in the Federal Register in order to come into compliance. After receiving a lot of comments after the initial release of the order, they backed that up to 1 year. So now you will have 1 year after the new regulations are printed in the Federal Register to comply. We anticipate that's going to be January of 2025. I was kind of hoping it would be released today because then it would have meant we were timing this webinar perfectly. But unfortunately, as far as I've looked so far, it has not been released. But it generally takes about a month. It was released on the 18th, so I would anticipate here sometime soon. There's not been much focus on D&C implications, and I think that there is a reasonable argument that nothing in this order changed the D&C requirements. And when I say the D&C requirements, the type of prior written invitation or permission you needed to call somebody on the do not call list. But I wanted to point out some of the context that in this order the FCC had in footnotes, which, don't we love it? It just seems crazy that such an important rule with so many really far expanding end business kind of implications is that we're worried about footnotes, kind of like the Facebook versus Duguid Supreme Court order, where they put into a footnote about capacity comment, which you can call me later if you want to talk some more about that, because it was a footnote on the brief that we had filed on behalf of PACE. But you know, in this order that the FCC released, I've highlighted the information, and they talk about how the callers are still required to meet the do not call consent requirements. And they focus on the fact that adopting here, they're making it clear that the consent must be between the consumer and seller in the singular, not sellers. And so this is something you're going to want to ask your attorney about. You're going to want to get an opinion on this and have a defendable position, as I'll point out later. But you know, this is one of the things where they seem to imply that it has always been the case with the type of consent that you need to call somebody on the do not call list, that it would be to a seller. And so if that's what it means, then we're talking about one-to-one consent for do not call. And I've seen so many questions that come in that say, okay, so Michele, why do we care about this? We're not using an ATDS. We're not using pre-recorded messages. I'm not saying the sky is falling here, and this absolutely applies to do not call. We're going to try to get some clarity around this. But this type of language in the order does confuse things, and they haven't provided any additional clarity on it. If you go to the next slide, though, I want to give you some fodder for why it wouldn't. And so, you know, they talk about how other sellers could be included on the web page for reasons other than obtaining consent. And then they talk about the, you know, for contact that does not require the prior express written consent, and that would be do not call. The other would be for calling consumers that are on the do not call list. And they also emphasized in paragraph 13 that it only limits sellers from robocalling and robotexting consumers who did not explicitly consent to receive those communications. So again, focusing on the fact that we're not changing the do not call requirements. We're really only changing the requirements for ATDSs and pre-recorded messages. And then finally in 39, they talk about how you can initiate calls and text to consumers without using an auto dialer, pre-recorded or artificial voice message. But you know, we do have some concerns about do not call. It's just worth it getting, if you go to the next slide, making sure that you do have some type of defendable position around here. Also, the other interesting comment from the FCC in the order was, they said that you can use electronic forms, web pages, provided you meet the e-sign requirements. And we've all known this. This has always been the requirement. The FCC has always said you have to meet the e-sign requirements. And what that means is that you're required to get the consumer's consent to deliver these disclosure notices in an electronic format. And so in order to get e-sign consent, you've got to get consent to use e-sign before you provide the disclosures for the prior express written consent. So consult legal counsel about this. Make sure you're doing this in the proper order. I think you can do that all in one form. I think you can also put it with privacy and terms and conditions in order to get the e-sign consent. But the FCC did stress that. So important for you to look at it too. Next slide.
Michele, I'm gonna ask you a question that's coming in, and we have a lot of questions coming in, so we're gonna try to throw some of the questions in throughout the next slides. What if a lead buyer is manually dial and texting? Think about the small lead buyers who don't have the automated dialing or SMS system capabilities. Do they need express written consent to contact the consumer who fills out a lead form? And I think this is one of the bigger questions that is just still unclear. What would you answer to that?
Yeah, I would just add in there if you're not using an ATDS, or if you're not using a pre-recorded messages, because those are the two areas where the prior express written consent would apply. I would just go back to the do not call conversation or discussion that we just had. That could be an issue. I think likely not, but you're going to want to make sure that you get an opinion on that. And so, no, this is really primarily affecting calls using an ATDS or a pre-recorded message.
One other question while we actually have the before and after slide, which I think summarizes what we touched base on. One other question that came in is, can you gather prior written consent verbally over the phone if you're already on a call with someone who has not yet given consent digitally through the web form?
Yeah, so the answer to that is likely no, because what the regulation requires is that you get consent for any of the sellers that would be involved in the process. So, I think that you could probably use a form that had the seller and then any cross sales that you would be trying to make on that, and have the consumer check both of those. But prior to this, and the FCC had put out commentary that you could get prior express written consent using a recorded voice. So now insert the e-sign discussion that we just had, but that you could get that through a recorded voice. But they have subsequently clarified that if there are additional sellers that call can be transferred to, that they should be included in the prior express written consent language. And probably should just say, because we didn't say what prior express written consent is, the elements are that has to be in writing, has to have the signature of the person, it has to clearly and conspicuously disclose that the purpose of this is to be telemarketed to the calls that subsequently will happen. They have to disclose the telephone number that the consumer is consenting to be called. And they have to disclose in that language that consent is not required as a condition of purchase. And those are the elements of prior express written consent.
Okay, one more question, and please jump in as well where you see fit for addressing these questions. One more question from mine before we jump into some of the expected impact from the three of us. The question is as follows: if manually dialing TCPA consent is not needed, but if the consumer is on a D&C list, will the general consent on the lead aggregator lead form cover the PSC requirement, or does that need to be a one-to-one consent as well?
So this could be a very long conversation, but I will tell you that we don't have great guidance from the FCC, as I've already talked about. But what the FTC has previously said, and the reason I keep referencing the FTC is that when these do not call laws were passed, Congress gave the directive that the FTC and FCC coordinate their efforts so that they would have uniform laws out there. And so in 2006, the FTC released an informal staff opinion. So let's just say informal staff opinion, which does not have the weight of law, but gives you an indication of how the FTC would interpret the law. And they were looking at a comparison shopping in the mortgage industry, and they were saying that if you have a lead form that doesn't disclose the specific seller but says you could be called by multiple mortgage company, multiple sellers, and even if you provided a list, even if you limit it to a certain number of callers, that did not create an existing business relationship EBR. So I'd encourage you to take a look at that, see what the FTC has said, and keep that in mind when you're making your decisions, creating your defendable position as to whether you are going to rely on the fact that the FCC has not said the exact same thing about the TCPA, or that that is a common regulatory approach to things, that it would not create an EBR. It's about your risk level there.
Hey, Michele, one more quick follow-up question before we jump into this, because I think this might be relevant for a number of folks on the line that are doing a lot of phone-based inbound phone lead generation. So you talked a little bit about the ability to gather consent while live on the phone with the consumer, potentially with multiple sellers involved, and how that might be challenging. Do you think about that similarly or different for like an end brand seller who maybe is purchasing inbound calls from a lead generator, or wherever they're coming from, they're driving consumers to call them inbound, they get them on the phone, and then they want to be able to gather consent to call them back in the future with follow-up activity? How do you think about that scenario?
Yeah. So, a couple of things there. So, the safest thing would be to have the seller as well as the inbound call or the lead generator that'll be transferring the call to the seller to have both of their names. And I'm assuming that this is an outbound call that's leading to a transfer is the situation that we're talking about, not an inbound call that the consumer has made to the lead generator.
Yeah, I'm thinking about the latter actually, where like a consumer might call in potentially directly to a brand,
Yeah.
like say they call a school or an insurance company and they're looking for information. They're having a conversation and they don't close on the line, but the agent they want to be able to gather consent to call them back and keep marketing
Correct.
to them. Does that workflow still work?
Yeah, that workflow can still work, and the FCC has pointed that out, that you can obtain the consent to make a follow-up telephone call while on a telephone call, provided you record that and you maintain the recording so that you can establish consent. And the disclosure language that we just mentioned for prior express written consent is included in that, and you get a consent to do it electronically to meet the e-sign requirement. So yeah, you can. There are definitely ways that you can do that.
Okay, thanks for clarifying that. All right, so I think we want to jump in here with the last couple of minutes to some of the expectations around what we think is going to change and what we think the impact might be. And I think this is where we start to step further into opinion and prediction outside of just the facts about what's occurred thus far. I think one key point to reference back to earlier is around the use of hyperlinks in TCPA disclosure statements, right? Which again is pretty commonplace today across the industry, and this is something that I think is clear in the regulation is going to change and no longer will be acceptable or will be considered compliant moving forward. So this primary shift for from being able to gather consent for many different companies and include all of that stuffed into one consent statement towards gathering one-to-one consent, needing to be explicit about listing the brand that you're gathering consent for, and doing that on a one-to-one basis. That's really, I think, the core shift that we're expecting to start managing towards and trying to figure out how to resolve across the space. With that, I think is also this second point around the logically and topically related content on the website to the services that the seller or caller is then talking to that person about and offering to them. That this is likely to create some challenges for cross-selling and multiple verticals being involved in the follow-up from a single lead, which does exist today across our space. And we see crossover between insurance and mortgage and home services and co-registration and various different products and services that can be marketed to someone after gathering consent one time. That's going to become more challenging to pull off in a compliant way moving forward based off of this. And then Michele or Boss, I'll let you guys jump in here and add further context on some of these if you have points to make.
Boss, I'll defer to you.
Well, I'm curious about the second to last bullet point here, the influx of lawsuits filed by class action attorneys. Because if you think about it, if the solution is to move away from ATDS and actually move towards manual dialing, the proof of consent is probably going to be more important. Well, maybe the proof of consent is not actually always needed in all cases. So maybe, Michele, I'm going to turn it back to you. What is your thought about the increase in the influx of the actual cases and how can parties in the industry weapon themselves or defend themselves the best possible way, knowing that might be a likelihood?
Yeah, it's a certainty. I tell you, when we do our year anniversary, I will be willing to bet that lawsuits increase at least by 10% after. Actually, we'll be doing our 2006 webinar after the regulations go into effect. And, a lot of it is because, the consumer class action attorneys are going to want to solidify the law here. Some of the things that we've talked about that could be questionable, they're going to want courts to weigh in on that and to get positive rulings there. So you can be sure that the plaintiff's attorneys will be doing a lot of test cases, and you want to make sure that you are not one of those companies that involved in that. I also wanted to just point out that a lot of people have asked, is an artificial intelligence call the same as a pre-recorded message? And obviously the technology is different, but what the TCPA prohibits, we've been saying pre-recorded messages, but it prohibits the use of synthesized voices or a artificial or a pre-recorded voice. And so that, artificial voice is what's being used when we're using artificial intelligence. So there was an article actually that just came out from the AGs. I think it was probably released yesterday, where they wanted to say unequivocally that they thought it was their opinion that under the TCPA, AI constitutes that artificial voice that would be covered and would require prior express written consent and to meet logically topically one-to-one consent requirements. So for all of you that asked that question, then yes, AI is definitely something covered by the TCPA's prior express written consent requirements.
Okay, a couple of items that we also wanted to address is more about the technical changes and campaign changes that we expect to be changing in the industry. And we'll talk a little bit more about this in obviously next session's webinar. We're going to talk more about the perceived solutions in the industry and potentially how we could help with that. But a couple of items we wanted to highlight today, where the industry today is very much focused on generating a shared lead that's matched up to multiple times, up to 4, at times at 5 times. We believe that there will be an organic shift to more exclusive leads, and that can be done in various different ways. It can be done through more of a branded campaign, where the advertiser, the buyer of the lead, is actually being presented all the way from the start of the creative to the landing page to the consent. But also actually when it's a category focused lead, let's talk about solar, for example, where there's just one particular company being listed. So that's definitely, I think, a change that a lot of peers in the industry are talking about, and a lot of solutions are being discussed. And that's probably one of the ways that actually the one-to-one consent will be supported. And one-to-one consent, as Michele highlighted, can be done for one advertiser, but we also know that it can be done in various different ways, where there's alternative flows to be thought out of, where multiple advertisers are being selected. I know I'm using the term enterprise buyers or advertisers throughout each other, but definitely the expectation is that particular enterprise buyers will shift towards requiring a one-to-one consent. And that's why it's so important today to prepare in advance. And I remember, Michele, when you talked about the kickoff of the TCP disclosure in 2013, literally kickoff day, there was a lot of scrambling, and literally within the first 48 hours, no one knew if a checkbox was required and no one tested it. And I think this is really an opportunity to test what flows actually have impact on conversion rates as well. We touched base on a couple of times, and there's quite a lot of questions that won't be all answered during this session, but we'll definitely follow up on. The belief is that more buyers will focus towards manual dialing as well, and potentially move away from some texting purposes. And even though that proof of consent is required still, it does create safety harbors in the way how consumers are being contacted. We touched base already on the different ways that we expect there's going to be innovation in terms of different flows and different forms that will be presented to the consumer. We're going to go very deep on that next session, where we're going to show those different flows as well. So I don't want to spend too much time on it today. The last 2 points are obviously focused on technology, and I started by saying that around the collaboration, but I think it's going to be really, really important that we think about how we're going to make this as easy as possible with all parties involved. And there is a lot of working together already today. Think about aggregators or brokers or different systems that we're all using or connecting to. So I think that thought and that the purpose of being so focused on automation through technology is going to be key. And I think we're going to see quite some innovation in the ways how this can be implemented, both on the front end on forms, but also for lead buyers to ensure that they know if a one-to-one consent is actually available on the particular lead. Last one, we strongly believe that this will also create more centralization for enterprise buyers to manage their vendors in an easier way, where it's not going to be as disjointed or not centralized. Because if you need to manage this all, the only way to do it is obviously having the right overview and the right controls in place. Bunch of other topics that we could touch base on today, and I think it's probably most effective if we actually take a look at one more or two more questions. So I'm going to defer to you, Eli, if you can pick one of the or two more questions.
Sure. Yeah, I'll pick one out. I think there was a question earlier about like implications for email-based marketing or follow-up, which is maybe related to one of the prompts we had on there about like alternative monetization strategies for leads outside of, you know, outbound phone dialing. Michele, anything you can add on implications for email? Does that come into play at all here, or is that fully separate from the order?
Completely separate. Email is controlled by the CAN-SPAM Act, and no private right of action for the CAN-SPAM Act basically requires that you accurately disclose who the sender of the email message is, and that you have a live you have an opt-out mechanism that stays alive and works for 30 days. Greatly simplifying that, but that's generally what you're looking at for that. And the other interesting thing about CAN-SPAM Act is that preempts state laws. So in that area, it's one of the few where you only have to worry about the federal regulation with how you send text messages or email messages. I should say too, because we didn't specifically mention this, the FCC did say that, you know, although I think all of us have already known this, that text messages are telephone calls for purposes of the TCPA, but they said they wanted to make that abundantly clear. So that was also an effect of this order.
That's helpful. I think that'll be interesting to see with this may lead to more use of email as a follow-up or reactivation or kind of remonetization play. Because even if you're, you know, like limiting the degree to which you can sell a lead that has full TCPA opt-in and consent on a one-to-one basis, you may still be able to monetize by passing that lead to someone who's going to follow up with email and reactivate and engage them and then gather new consent before selling that lead again. So that's one to watch, I think, as we progress here.
We might have to get the Direct Marketing Association back for actual physical mail letters now.
That'd be an interesting outcome of the update if it leads to more physical mail showing up at our homes. Another question that came in here was since lead generators will need to pre-ping lead buyers and present only 1 to 3 sellers, shouldn't they do more to intelligently match buyers to sellers? Boss, you want to chime in on that one?
Sure. I actually love that question, and because I think there's a lot of room for improvement on how leads are being matched today already. And not only talking about how they're being matched on a form, but even how ping post systems are working and all the issues that everyone is encountering in the space. Think about acceptance rates, think about duplications, think about a lot of challenges in today's ecosystem, which is all slowing down the ability to actually contact the consumer. We'll talk a little bit about where we see opportunities for that to improve that. But I think the question is mostly tailored towards how to do that on the form to actually give the consumer the choice of which consent they want to give on a one-to-one basis. I think that's key to talk more about that in particular, because there's going to be more sophistication needed to ensure that the same buyer is not going to pop up twice, for example, right? If you think about how a buyer name can be listed, it can be listed as just a single entity name, but it can also be with LLC behind it. And there's going to be a lot of issues with duplications that can actually cause consumer challenges within the process of their choice that they're making in the form. So we definitely need to work towards a unified way of making sure that those companies can be matched. And there's been quite some discussions on what that could be. If that's a Dun & Bradstreet number, which we're all matching towards the same company name. If that's a federal I number that's being matched, there definitely needs to be matching that's taking place to ensure that the same company is being meant to be matched all along the process of how systems today are connected to each other. But again, we'll talk a little bit more about that in the next session as well. What some of the thoughts are that we think we need to collaborate on. Yeah, one more. Go ahead, Michele.
There were a couple questions about if somebody records their own voice and uses that as the pre-recorded message, does that require prior express written consent for telemarketing calls? And so I can tell you, we've been involved in a couple of AG multi-state actions, and the attorney generals most definitely believe, even if you're using your own pre-recorded voice to leave a message on a voicemail system, that is a pre-recorded message, and that would require the prior express written consent under the TCPA and their equivalent state laws. So that is an area that I think has a tremendous amount of risk, even if you're recording your own voice or get permission to record. I think the question, or the one in here, was to use James Earl Jones' Darth Vader voice, and you got consent to do that, then would that actually be a pre-recorded message? And I will tell you that the regulators have unequivocally and unanimously answered yes to that question. It has not been challenged, I think, very thoroughly, though. So if this is an important issue to you, then maybe that's something to look at getting involved in a case that's already in litigation. I would also say it's worth noting that we are aware of industry associations that plan to appeal this order. And so I'm very familiar with that process from having engaged in it before, but probably will result, when this order is released in the Federal Register pretty quickly, some requests for reconsideration to be filed, and FCC responding to that. If it's not the answer that industry is looking for, then I most certainly think this will be challenged in one of the courts. It goes into a lottery depending upon who would be filing to have that order appealed. So it goes into a lottery system. Last time we did this, it ended up in the DC Circuit Court for the definition of ATDS and what capacity meant. So if you are interested in getting involved with something like that, you could reach out to us on this, and we can give you some thoughts about who likely will be appealing it.
We still have more questions coming in, and I was hoping to have room for one more question, but I want to be mindful of everyone's time because we're on the top of the hour at this point. So I want to thank everyone for joining today's session and actually being so super interactive. We had, I'm still trying to count them from all different angles, but we had, I think, close to 40 or so different questions. So we'll make sure that we can share those between the three of us and follow up where necessary and possible. But thank you so much for participating today. Reminder on next two sessions. The next one is planned for 2.5 weeks from now on Tuesday, February the 6th. And we'll talk a little bit about the solutions that we perceive to be the best ones to pursue for both lead generators and lead buyers, and the way how we can actually help with some of the technology that both companies, both Verisk and PX, will be focusing on over the next few months to roll out. And in the third session planned for February 15th, we're actually going to do a deep dive in some of the use cases that we'll discuss in session 2 and see how they've actually already been quite active in today's industry. So maybe there's even not as much change as we were thinking prior to this call. So thank you so much for joining, and chat soon with everyone. Thanks.
Thanks, everybody. Appreciate it.